The Supreme Court just issued a 9-0 decision that has both political sides talking about this because it impacts the upcoming election. Now, real quick before we jump into the video, I want to ask you all for a huge favor. Looking at some of my channel analytics, about 60% of all viewers are not actually subscribed to the channel. So if you enjoyed this content, if you want this content to get out to more people, one of the best ways to support it is to just simply like and subscribe. Subscribing helps to push this out to more people so more people see this information, and again, it just spreads it more widely. But regardless, thank you guys so much for all of your support. As I mentioned in the intro, in this video, we're going to be talking about a 9-0 decision that was just issued by the United States Supreme Court today. This decision rules on Trump's presidential eligibility going into this election and a state like Colorado's ability to disqualify someone like Trump. Now, although this issue does not deal directly with the Second Amendment, the impacts of this decision is far-reaching. It impacts a lot of other things outside of just the election. For the Second Amendment community, we want to be able to vote for who we want. We want to have a representative of the Second Amendment cause. Now, personally, I have a lot of issues with Trump. I don't think he's the perfect two-way candidate. I have my own feelings about him. Specifically, remember, he's the one responsible for the whole bump stock issue. You know, back in the day, he was the one who advocated for the ATF to regulate bump stocks, and that has now spun into a bunch of other ATF overreach issues like the pistol brace issue, unfinished frames and receivers, and all of those things, and that was directly because of Trump. But also, to be fair, he was favorable to the Second Amendment in other senses because he put in place pro-Second Amendment justices in the Supreme Court, who ultimately led to that landmark decision in New York State Rifle and Pistol Association versus Bruin, and also he's helped to kind of change the composition of multiple other lower courts, circuit courts like the Ninth Circuit. So there are a lot of pros and cons, but I would say overall, compared to, someone like President Biden, he's much better for the Second Amendment. So some people probably want to vote for Trump over Biden. So that's why this is important, not just for the two-way cause, but a lot of other issues as well. The case we're going to be breaking down and talking about the Supreme Court just issued a ruling in was Trump versus Anderson. This case arose out of the state of Colorado's attempt to disqualify Trump for the upcoming election based on the Section 3 of the 14th Amendment. A group of Colorado voters contend that Section 3 of the 14th Amendment prohibits Trump from becoming president once again. The Colorado Supreme Court reviewing this case agreed with that contention. The Colorado Supreme Court, as a result, ordered that Colorado's Secretary of State exclude Trump from the Republican primary ballot in the state of Colorado, and ultimately to also disregard any write-in votes that happen in Colorado for President Trump. The Colorado State Supreme Court did stay that implementation and that decision until ultimately the United States Supreme Court reviewed and ruled on this issue. And what was at stake with this case was whether Colorado and potentially other states could disqualify Trump from this year's election using Section 3 of the 14th Amendment. And on review, the United States Supreme Court today issued a 9-0 per curiam decision, ruling ultimately that Colorado and other states cannot do this type of thing. That means that the court at large and in unison on the fact ultimately found that this type of action taken by the state of Colorado is in fact unconstitutional. Even the liberal judges agreed with this, position, and ultimately the, fundamental judgment and reversal of the Colorado State Supreme Court decision was in unison. So it was a 9-0 decision. That is because, the Constitution makes Congress, rather than states, responsible for enforcing Section 3 against federal office holders and candidates. So at large, that's what the Supreme Court said. Therefore, the court reversed that decision from down below. Now, despite a lot of the headlines you're going to see about, this being a 9-0 decision, it's not all sunshines and rainbows. That is not always how the, Supreme Court operates. There was a lot of issues in this decision from some of the dissenting opinions. And yes, I said it was a 9-0 decision, but there were still some dissents on a specific aspect of this case and how the Supreme Court majority ruled. 4 of the justices stated, 1 in a concurrence, and then also the remaining 3 in a dissent. They ultimately stated that the Supreme Court majority went too far in this decision. Now, for those coming to Supreme Court cases for the first time, this specific decision is a per curiam ruling. That ultimately means that the majority opinion was not authored by any specific justice. Usually, if there's a majority opinion, you would have like one specific author, like Justice Thomas, who would write for the majority. But this, was authored in a per curiam, which means no specific judge was identified as writing the opinion. It's just simply an opinion of the court. Probably because this is so political and so politically charged, they don't want one specific justice to, be writing the opinion. Instead, it's an opinion written on behalf of the court at large. The interesting thing about this decision, like I mentioned, is that all 9 justices agreed in the ultimate outcome of the decision. They all agree that Colorado does not have the power to do what they did. They all stated in the opinion that responsibility for enforcing Section 3 against federal office holders and candidates rests with Congress and not the states. Therefore, they reversed the prior decision. The main holding of all 9 judges is that they agree on the following. They all stated that this case raises the question whether the states, in addition to Congress, may also enforce Section 3. We conclude that the states may disqualify persons holding or attempting to hold state office, but states have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. In this section, the court stated that nothing in the Constitution delegates to the states any power to enforce Section 3 against federal office holders and candidates. As an initial matter, not even the respondents contend that the Constitution authorizes states to somehow remove sitting federal office holders who may be violating Section 3. They go on to state in the opinion that the respondents nonetheless maintain that states may enforce Section 3 against candidates for federal office, but the text of the 14th Amendment on its face does not affirmatively delegate such a power to the states. The terms of the amendment speak only to enforcement by Congress, which enjoys power to enforce the amendment through legislation pursuant to Section 5. What this all boils down to is the fact that under Section 3 of the 14th Amendment, only Congress has the power to remove federal officials or to disqualify them through specific legislations. A state does not have that power. They cannot do that. Although this is a 9-0 decision on a reversal, it's not a 9-0 decision on the methodology for that reversal. In fact, 5 of the judges went beyond just that holding. I believe it was Justice Thomas, Gorsuch, Kavanaugh, and Roberts who seemed to be on the 5-judge side that wanted to go a little bit further and add a little bit more detail on the decision and what process, congressional disqualification can take, the type of legislation that would need to happen. So they went a little bit further. And on the other side, you had, the liberal judges, and then also Amy Coney Barrett, who wrote a concurrence saying that they do not agree with the 5 majority going a little bit further in their decision. Justice Barrett, who we've been a little bit concerned about going into some other cases, did write a concurrence expressing her frustration with the 5 other justices in their opinion, saying that she was only going to concur on specific parts of the decision. She stated that, I joined parts 1 and 2B of the court's opinion. I agree that states lack the power to enforce Section 3 against presidential candidates. That principle is sufficient to resolve this case, and I would decide no more than that. This suit was brought by Colorado voters under state law in state court. It does not require us to address the complicated question whether federal legislation is the exclusive vehicle through which Section 3 can be enforced. The majority's choice of a different path leaves the remaining justices with a choice of how to respond. In my opinion, this is not the time to amplify disagreement with stringency. The court has settled a politically charged issue in the volatile season of a presidential election. Particularly, in this circumstance, writings on the court should turn the national temperature down, not up. For present purposes, our differences are far less important than our unanimity. All 9 justices agree on the outcome of this case. That is the message Americans should take home. This sounds like Justice Barrett is very concerned about the political turmoil that might come out of this decision. And in her concurrence, she is trying to express, her issue what the majority did. And, maybe that they shouldn't have went beyond just the reversal of the Colorado law. And she's trying to kind of tone down some of the rhetoric and saying, hey, we shouldn't be infighting on the Supreme Court. Let's just issue something that's a little bit more neutral. Now, this frustration also is very present in the dissents of Sotomayor, Kagan, and Jackson, who are the liberal justices. They state in their dissent that today the court departs from the vital principle, deciding not just this case, but challenges that might arise in the future. In this case, the court must decide whether Colorado may keep a presidential candidate off the ballot and disqualify them from holding federal offices under Section 3 of the 14th Amendment. Allowing Colorado to do so would, we agree, create a chaotic state-by-state patchwork at odds with this nation's federalism principles. That is enough to resolve this case. Yet the majority goes further. Even though all 9 members of the court agree that this independent and sufficient rationale resolved this case, 5 justices go on. They decide novel constitutional questions to insulate this court and petitioner from future controversy. Although only an individual state's action is at issue here, the majority opines on which federal actors can enforce Section 3 and how they must do so. So what does this mean? First, again, understand that all 9 justices agree with the judgment. They ultimately all agree with the outcome that Colorado does not have the power to disqualify or remove someone from federal office, disqualify someone from running for office. The states do not have that power under this section of the Constitution. Therefore, they're striking down what Colorado said and they're reversing that decision from the Colorado State Supreme Court. So that's kind of the baseline ruling. Now, where there are going to be some disputes is that 4 of the judges think that the other 5 judges on the Supreme Court should have just ended the decision there. They shouldn't have went any further. But really, I think the 5 judges on the Supreme Court were doing that to try to, like they said, prevent some of these future actions from popping up, especially during this year of election. So, a lot of dispute. You'll see headlines talking about, the Supreme Court was unanimous. You might even hear some other things. Yes, they're unanimous 9-0 decision on the ultimate judgment, but there's still a lot of, dispute and infighting on how they reached that conclusion. So hopefully you guys got some information, some insight on that decision. If you guys have any questions, go ahead and comment down below, and I will try to answer the best of my ability. Also, if you like this video and you would like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like and subscribe, and don't forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.